Calling case number 14-1-1085, Clarence Ching et al. Versus William J. Ayala Jr. et al. For jury waived trial. Counsel, please state your appearances.
Good morning, Your Honor. David Frankel and Summer Silver here on behalf of the plaintiffs, Clarence Ching and Mary Maxine Cajaldalillo, who are both here with us in court today.
Good morning, Your Honor. Daniel Morris, Deputy Attorney General on behalf of the State of Hawaii. With me today in the court, Russell Suji, a client representative from the Department of Land and Natural Resources, as well as Chloe Oshiro, who's a paralegal with our office that will be helping me with some of the exhibits.
All right. Good morning. Please have a seat. All right. Any preliminary matters?
No, Your Honor.
None.
All right. An opening statement.
On its website, the Department of Land and Natural Resources proclaims that its mission is to enhance, protect, conserve, and manage Hawaii's unique and limited natural, cultural, and historic resources held in public trust for current and future generations. But actions speak louder than words. And when it comes to Pohakuloa, inaction speaks even louder. In 1964, the Board of Land and Natural Resources and its department entered into a 65-year lease with the United States. State General Lease S-3849 to use over 22,900 acres for military purposes at Pohakuloa for $1. Paragraph 9 of the lease requires the U.S. to make every reasonable effort to remove or deactivate all live or blank ammunition upon completion of a training exercise or prior to entry by the said public, whichever is sooner. Paragraph 14 of the lease requires that the U.S. government take reasonable action, commensurate with training exercise, to remove or bury all trash, garbage, or other waste materials. The Department of Land and Natural Resources' goal is to inspect the land that it leases every 2 years, once every 2 years. The department has not met this goal at Pohakuloa. It has not even come close. According to DLNR's records, between 1964 and 2013, DLNR inspected Pohakuloa just once, in 1984. And that inspection was so superficial that there was no effort to determine the Army's compliance with these two paragraphs, paragraphs 9 and 14 of the lease. DLNR's records indicate that it was going to visit again in 1994, but it never bothered to actually show up and conduct the inspection. In 2014, when asked for all the records that show DLNR's efforts to ensure compliance with the lease, the department said there were none. DLNR's records do show, however, that it was aware that military debris litters the landscape and that unexploded ordnance there poses a threat. But DLNR did nothing until after this lawsuit was brought. But not right away. DLNR waited. While this case was in federal court, DLNR did nothing. Before the first hearing in this case, DLNR did nothing. DLNR waited 7 months. The department waited until the day after this court denied its motion for judgment on the pleadings to contact the Army, to email the Army to try to schedule an inspection. That was last December. In March, when the Army announced its plan for cleanup of the heavily contaminated surface, DLNR did not even bother asking for a copy of the plan. Instead, DLNR has been negotiating a new lease to allow the Army to fire combat weapons at Pohakuloa for another 65 years. Yet the landscape remains littered with military debris that, according to the Army, presents a risk of significant danger to public health and welfare. At the conclusion of this trial, the plaintiffs will be asking that this court conclude that the defendants breached their trust duty. And the plaintiffs will be asking this court to order the DLNR and the BLNR to take action. The time for inaction is over.
Morris?
Thank you, Your Honor. Let me start out by saying that our United States troops need and deserve a place to train. Their mission protects all of our freedoms, our rights to protest, our right to appear in this very courtroom. Each one of us owes a debt of gratitude for those who have given their lives and put their lives at risk. And that's what this case is about. Pohakuloa training area is the largest and most important training area in the Pacific. And make no mistake, the evidence will show that plaintiff's goal in this suit is to prevent or delay the U.S. from being able to use state land at Pohakuloa. Boiling this case down to its simplest element, the plaintiffs state at page 10 of their proposed findings that the plaintiffs are only asking that the defendants avail themselves of all the rights they possess under the lease, nothing more. That's what this case is about. They're saying avail yourselves, DLNR, of whatever rights or all the rights you have under the lease and nothing more. And the evidence will show that their embodiment of that directive is that there should be inspection and enforcement. But there's a few huge flies in that ointment. The first is that in terms of the rights we possess under the lease, the state has no enforcement rights whatsoever under the lease. The evidence will show that in 1964, the United States was prepared to take all of these lands so that the state would no longer have any interest whatsoever in these lands. They were going to be set aside for military purposes exclusively, similar to the 100,000 acres or so that are up there now. They were going to take them. And the state knew that. The evidence will show that at the highest levels of government, from Washington, D.C., to Governor Burns, our first governor, that there was a discussion and an effort by DLNR to save these lands from being taken and set aside by the United States. And they succeeded. And it came at a cost. It came at a cost that arose in the negotiation of the lease. The state attorney general asked the military, they said, please put in an enforcement provision so that we can enforce the requirements of this lease. They didn't want a normal, innocuous provision. They said, well, at least give us something where if there's a willful breach that persists over time, then we can take enforcement action and terminate the lease. The word from Washington was, Washington, D.C. says no. That doesn't get in the lease. The Attorney General argued that that's tantamount to a criminal penalty with no sanction whatsoever, that it effectively renders the requirements of the United States meaningless. And the word was, take it or we'll take it. Not take it or leave it, take it or we'll take it. The state had no bargaining position whatsoever, and the consequence of that was that there is no ability of the state to exercise rights they possess under the lease for inspection and enforcement. There is no right of enforcement under the lease. The second flaw in the ointment of this inspection and enforcement model, Your Honor, is that the requirements of the lease are so obviously obsolete in light of current federal regulations, in light of modern safety standards, and in light of the military's own regulations and procedures for cleaning up their training areas. They're obsolete, Your Honor. Paragraph 9, for example, it doesn't say clean up after training exercises. What it says is remove or deactivate live or blank ammunition after training exercises. That's basically UXO removal. Well, since the lease was executed, the military has incredibly detailed procedures to remove UXO from training exercises. The evidence will show that those procedures are so detailed and rigorous. And why would the military incorporate these detailed and rigorous requirements for removal of UXO after training exercises? And the answer is simple. They're protecting their own troops. These troops are the ones that use these training exercises. So you'll hear evidence that when a training exercise is completed, a field training officer is required to identify any live or ammunition that hasn't been deactivated. They got to clear the area. They got to remove trash. They got to file a certification form that says that it's cleared. And that training group that used that area can't go back there until they've gotten a certification of clearance. The detailed requirements of federal regulations with respect to UXO removal absolutely make the provisions of the lease obsolete. In addition, paragraph 14 that talks about in consideration of the limited amount of public use of the area that they're going to remove trash or dispose of trash. Likewise, the lease talks about burying the trash. Modern trash disposal requirements make that requirement absolutely obsolete. The evidence will show that the Department of Health has inspected the landfills and trash removal process at Pohakuloa repeatedly. Not pursuant to the requirements of the lease, but pursuant to modern standards for trash removal and trash disposal. Both paragraphs 9 and 14 of the lease are completely obsolete. And the third fly in the ointment of this inspection and enforcement model that the plaintiffs insist the state should adopt is that we're talking about 23,900 acres of lava-covered property that has been used by the military for nearly 75 years. It defies common sense, Your Honor, to suggest that the single state land agent for the Big Island is going to be, who is responsible, the evidence will show, for over 1,000 leases, is going to traipse through a Stryker Brigade training area to make sure that the munitions experts from the military have properly cleared the area. It's ridiculous. There's no way that that we can double check the UXO removal work of the United States military. It's just impossible to do. The plaintiffs suggest that, well, one or two people with appropriately well-covered shoes, a clipboard, and a camera cover the entire area in 1 to 3 days. Well, this is the size of Pohakuloa. This is an extremely dangerous area. You're not going to test if they remove UXO with a clipboard or a GPS device. So what's the alternative? Instead of this inspection and enforcement model, there's a different way of ensuring protection of natural resources and meeting the mission of the Department of Land and Natural Resources. It's through interagency cooperation. And the evidence will show an extensive array of interagency cooperation, successful interagency cooperation. As early as the 1960s, Your Honor, the state and the United States government entered into an agreement for a cooperative plan for the conservation and development of fish and wildlife resources. In 1995, with the support of Senator Daniel Inouye, an ecosystem management program funded by millions of dollars was initiated that the state participated in. In 2002, an integrated natural resources management plan was developed in conjunction with the state. And it's clear in those documents that the primary responsibility for enforcement of environmental regulations and these responsibilities is with the United States, and appropriately so. Because what you'll see in this agreement, this interagency cooperative model of land management, what you'll see is that they propose that each party bring their expertise to the table. Clearly, UXO removal is the expertise of the military. What the state brought to the table was management of hunting reserves, archaeologists, efforts to assist the United States government in acquiring rights of entry for saddle road realignment or removing of poles, successful cooperation, and even some pushback by the Department of Land and Natural Resources. Lines of communication with the military pointing out that they need to be sensitive to the hunting areas, that when they've tried to expand beyond the state lands of Pohakuloa training area, that the conservation district rules apply. You'll see in 2004, there was a programmatic agreement executed between the Office of Hawaiian Affairs and the United States military. And in that agreement, it allowed for cultural monitors to go along with the contractors and so on that are working on the battle area complex for the Stryker Brigade. And that shows that there are eyeballs on this property. Cultural monitors through the State Office of Hawaiian Affairs, landfill inspections done by the Department of Health, military munitions response programs developed in 2004, land condition trend analysis by the United States Army. There are eyeballs on this property. There is monitoring of this property. And everybody brings their area of expertise to this interagency cooperative model of land management. Now, the plaintiff's case starts with the premise that they're not alleging that the United States has breached this lease in any way. No allegation of any breach whatsoever, stated right in their First Amendment complaint. The plaintiffs are not parties to the lease. There is no evidence in the record. You won't hear any evidence of any damage to archaeological sites for military activities at Pohakuloa. You won't hear any evidence of anyone ever injured by unexploded ordnance, military troops, members of the public. Over 50, 60 years of use of this military training area, no evidence of any injuries from unexploded ordnance. In fact, you hear evidence that the plaintiff has acknowledged that the United States has worked to protect archaeological and natural resources. You'll see environmental reports that show that there are actually some benefits of the military's activities at Pohakuloa because of restricted vehicular access. And in fact, some of these archaeological sites are better preserved because of the fact that they're on a military training area. So you have these two management styles, Your Honor. You have inspection and enforcement, and you have interagency cooperation. And the record will show an abundant and vigorous, not a lazy use of interagency cooperation, but a vigorous and vibrant one. And I mentioned at the outset that the plaintiff's goal is saying, well, avail yourself of all the rights you possess under the lease. But I want to talk about a couple of legal concepts that really have to guide this case. Because the plaintiffs are not parties to the lease, a question arises, and they're not alleging a breach of the lease. What is their basis to come into court here today? And in the Pele Defense Fund versus Patey case,
Objection, Your Honor. We're getting into argument rather than
Sustained.
statement.
the only issue before this court, Your Honor, is whether or not there is an impending breach of trust about to occur. And you will not hear any evidence of such an impending breach of trust. And that's the only basis for the plaintiffs to be here in court today, to establish that there's some upcoming breach of trust that this court must take action to address. Now, the evidence will also show that there is an ongoing cleanup effort by the United States in cooperation with the state of Hawaii. And that cleanup effort is really the fruit of this interagency cooperation because it was based upon voluntary disclosures by the military of areas that need to be cleaned up, voluntary efforts by the United States to go ahead and clean them up, and you'll hear evidence that they're in the middle of getting cleaned up. And still, in light of all of this, you won't hear any allegation that any of this is a breach of the lease. The fact that this ongoing cleanup is underway and has not yet been completed absolutely means that this case is moot, Your Honor. So again, the plaintiffs are saying the defendants should avail themselves of the rights they possess under the lease. We have no enforcement rights under the lease. It's not practical for us to check for UXO. The requirements that they point to, paragraphs 9 and 14, have been overtaken by federal regulations far more strict with their own monitoring agencies. Nuclear Regulatory Commission, Environmental Protection Agency, Fish and Wildlife Service, EPA. There's a network of federal regulations that the state doesn't have the power to enforce. We have rights under the lease. It's a conservation district. But those requirements are unenforceable and have been overtaken by the cleanup requirements that the military has in place, as you'll see in the evidence. So I hope that the court...
Objection, yeah, we're going beyond 15 minutes now.
Let's wrap it up.
Okay. I just want to make sure that we keep a focus on what evidence is there of some impending breach. There really is none. If they're suggesting that the impending breach is the execution of a new lease, the evidence will show that that negotiation for a new lease is really the way the state can meet their duties as a trustee. We can get back land that the United States military is no longer using, back from the U.S. military. But if we can't negotiate with them, we can't get that back. We can update the leases, as the state auditor has suggested the state do. Update those leases to have more modern clauses that are not obsolete. That's an opportunity to serve the public trust interest and to improve the conditions at Pohakuloa. And if we're barred from negotiating for any new lease, then the military, you'll see evidence that they're just going to take it with no control whatsoever by the state. Our one point of leverage is the potential of a new lease. Leverage to accomplish our mission of the Department of Land and Natural Resources. Gather back lands for use by the public. So I ask that we keep that in mind of what future breach is occurring, and I suggest to the court the evidence will show there is no such. Thank you, Your Honor.
Thank you.